The paper tiger. Why your LLC is probably a lawsuit waiting to happen. Right now, thousands of people are setting up LLCs because they believe it is the ultimate way to protect their assets. They assume their house, their savings, and their retirement are completely off the table in a lawsuit. And most of the time, they are right on paper, but that is the exact reason this belief is so dangerous. Millions of entrepreneurs are walking around with a false sense of security, unaware that their LLC is a paper tiger waiting to collapse. The second a real lawsuit hits, a good attorney is going to look right past your company and come straight for your personal bank accounts. You do not have to commit fraud to lose your shield. You just have to make a few quiet, everyday mistakes. In a landmark 2002 case, the court made it clear there is no reason to treat LLCs differently than corporations. This means a court can pierce the veil and let a creditor reach your personal assets if they decide your LLC was never really separate from you. One of the easiest ways to lose your protection is to let your entity expire. Susan, for instance, forgot to file her annual reports, and the state administratively dissolved her company. She kept signing contracts, but because the business no longer existed on paper, she was personally liable for everything. About 18 to 24% of the people we work with have an entity they think is legal when it has actually been dissolved by the Secretary of State. You must use a compliance calendar or a monitoring service to ensure you stay in good standing. Another common trap is failing to act through the entity. If you sign contracts, send invoices, or hand out business cards in your own name instead of the LLC's name, you're handing an attorney a simple argument. My client did business with you, not your company. You must sign in your representative capacity. This requires knowing if you are member managed or manager managed. If you're a manager, you sign as a manager. If you're a member, you sign as a member. Every document is a chance to prove you are acting as the company. If you ignore the separateness of the business, the court will too. Then there is the big one, commingling. If you treat your business like a personal wallet, paying your mortgage or grocery bills out of the LLC account, you are failing the basic test of separation. Courts call this a unity of interest. To fix this, you must take a formal distribution from the LLC to yourself personally before paying for personal expenses. Similarly, avoid undocumented draws and loans. If you borrow money from your own company, you need a promissory note with interest rates and repayment terms, just as if you were borrowing from a bank. You must create a paper trail that explains exactly why funds are moving. You must also avoid the undercapitalized shell. If you set up an LLC with only $1 in the bank and no insurance, a court may decide it is just a liability sponge you are hiding behind rather than a real business. Finally, ensure there is an arm's length between your various entities. If you have multiple LLCs and use one to pay the bills of another without documenting it as a loan, the court can collapse your entire structure into one giant target. If a lawsuit starts in one company, everything you own could be at risk. You must be deliberate about how money moves. Setting up the LLC was step one. Making sure it actually holds up when tested is the real work. Please subscribe so you will be notified of new uploads. Press the like button. It helps our algorithm. Thanks for watching.